Okay, so then the court need not rule on document 682 since the opposition's been withdrawn, and there will not be any references to Casey Aiken working at a strip club.
I both agree that he is incapable of telling the story without saying Russians a couple times.
Okay, Counsel, you're talking about Real Waters motion limiting number 1 to preclude admissibility of the consent decree?
I sure that was granted.
Right, I just want to make sure that that's what, I had to know what real terrible Herbst is actually referring to, and she thought it was a different one. So, Counsel, can you just enlighten which one you thought it was next up?
Sure, Your Honor, and maybe you can just disregard my comments, but I had docket number 609 coming up after our...
I ruled on that.
Okay, I must have missed that. I don't know why I wrote that down on Friday or whenever we were there last.
Don't you all show I ruled on?
Yes, Your Honor. You ruled on 609 on December 15th.
Right, I've got all my little notes on it.
You initially announced that on Friday, and I wrote down 609 too, but I crossed it out because clarified that that.
Right, I scribbled
Yeah,
it
same
off.
thing, it was on my list, but crossed out.
Right, because it said argued on 12, yes. Okay, you all agreed that it was, yes. Okay, so, fine. Everybody's understanding by the court's ruling, see the record. I already ruled on 609, Real Waters motion limiting number 1. So 473, Terrible Herbst motion limiting number 1, we're deferring to Wednesday. Okay, so we have to put that on our Wednesday. Just wait a second. And so then I show the Russians is what was coming up next.
Real Water agrees.
Pardon?
Real
Yeah,
Water agrees, the Russians are next.
yeah, which originally was gonna be my 8th one for today, but really now is really the 6th one because of the changes in the other 2. Okay, so document 680, Terrible Herbst motion limiting number 8 to exclude the reference to the Russians. Counsel for Terrible Herbst, go ahead, please.
Yes, good morning, Your Honor. Trevor Everett on behalf of Terrible Herbst. We did discuss this briefly, and if there is any discussion that we need to have regarding whether or not we'll be hearing from Mr. Marlowe in person as opposed to depositions, and that can be a discussion that we can have. Regardless, we would argue that the references to Russians, especially in light of the political climate in our world this time, are not relevant. Regardless of this individual's heritage, whether or not they have any relation to the claims in this case made by Mr. Hunwardsen, that should not be considered. We wouldn't be discussing this in light of gender, sex, religion, and we feel like those comments should not be included, should not be presented to the jury, and for those reasons, we would ask you to grant this motion, and I'll reserve any remaining time for, if necessary, after we hear from the other parties.
Okay. Water, I do not see that you had a position on this, is that correct?
That is correct, Your Honor. We did express concern of keeping control of Mr. Marlowe at trial.
I was going to say, this is the one that you all made a reference of, basically good luck with regards to certain comments on that. And I said that I would be more than glad to do witness management as part of the court's gatekeeping functions and remind witnesses what they need to address and not address, but it wasn't substantively ruled on by the court. So, Counsel for Ruwater, did you, other than a witness control issue, did you have a substantive?
That's our only issue, Your Honor. Thank you very much.
Counsels for plaintiff, go ahead, please.
Yeah, Jane, can I have Mr. Marlowe's deposition testimony? Yeah. Your Honor, Mr. Marlowe is the inventor. Video? No, just that quote I gave you from the opposition. So Mr. Marlowe was the inventor of the Real Water product. Basically, he got these two, actually he got more than two, he got like 10 or 12 of them, titanium tubes from what he identifies as the Russians back in the 80s, I believe he says. And in his second deposition, we actually got some names, and they're Russian names. But in his testimony, he just refers to them as the Russians. And so, like I've said before, Mr. Marlowe's 82, 84. He's told this story 3 times now because we deposed him twice. We had him on trial one time. And I think Mr. Odou and I both agree that he is incapable of telling the story without saying Russians a couple times. Okay, so we're not trying to take advantage of this or exploit this in any way, shape, or form. In the Gallagher trial, during the opening statement, instead of talking about Russians, I referred to he met a European gentleman, and then Hannah went ballistic because their factory is in Romania, so they thought I was trying to imply that they were involved with the invention of the titanium tubes. So that workaround turned into another problem. So sometimes you just have to use the word Russians, But I don't. It's not a big deal. We don't intend to use the term Russians unless we have to. But I just don't understand the concern here that Trevor Herbst has that there's some. Here's the testimony. Okay. As a result of this catalyst work I did, basically was trying to invent a fuel catalyst. Ironically, working with Mr. Blaine Jones on this project, or Brent Jones, excuse me. As a result of this catalyst work I did, I encountered a gentleman from Russia. His nephew and niece were living here in Las Vegas. He had developed an electron device in Russia. Okay, so there's no implication that the Kremlin was involved in this, that this was Russian military, that there's some sort of, diabolical device being invented that was hoisted onto real water. All he says is he met some guy from Russia. And I just don't think that is objectionable in the first instance, but I think trying to excise it out of his testimony when he gets here is going to be nearly impossible. So I'm happy with not using the term Russian during opening statement or closing statement. I don't know what term they want me to use. He met a foreigner. I mean, I think that's even worse. But I just don't think there's a big reason for prohibition, but I'm willing to do anything the court wants to do.
Does it matter the origin of the individual, where he got these titaniums versus an individual who was living here in Los?
It doesn't matter.
Okay. Real water, does it matter from your end?
No, Your Honor. It's, as people get older, my parents went through this, they tell the story the same way no matter what question you ask. Mr. Marlowe is of that generation, and so we just can't stop him.
That's a different issue, which I got an idea on that one, but okay. But from real water, does it affect any of your defenses at all?
It does not. We had the same concerns that Terribles did, and the way it came out at the Gallagher trial, if it comes out here, it's the same way. It's innocuous.
Okay. Counselor Trevor Herbst, you've already raised the concept. So let me tell you, here's a potential idea. Potential idea is that, whether you all think it's good, I don't know, is that prior to Mr. Marlowe's testimony, I can explain to him that there's been a ruling that, he can mention that he met somebody, but that he should try not to use the word Russians. Seems to me that may or may not work.
He's got to use their name, and that's even worse for Trevor Herbst, because the name, I can't remember, but it's Vitaly Solzhenitsyn or something like that. It's a clear.
It's Alexander Solzhenitsyn. He'd be very happy, right? That has the opposite concept. Sorry.
I don't know what the jury what that'll have impact.
Happens to be the book he wrote. Yeah.
They hear long Russian. Yeah, they hear a Russian name. They're gonna think, oh, Russian.
Okay, gentlemen. Well, that's okay. Let's try and find it. Another alternative is that you all stipulate basically to a curative. So if he does say it, and you all feel that it needs to happen at the time of trial, that you could have the fact of a person, and you can even have the court in a pre-instruction. You're going to hear that there's people, we know that this is a community in which we have people from all around the world. You can't take into account any of the race, religion, sex, national origin, sexual orientation, nationality of any of the witnesses, etc. that's going to take place. Do each and every one of you, ladies and gentlemen of the jury, understand that? I can do something like that as if you all want.
Do that, Your Honor. If it turns to be something that's potentially inflammatory, we have no objection.
I'm just saying, but you can even have this court, if you're wanting it to, right, with regards to when I kind of explained the juror process, right, that I can have a sentence that, they may hear testimony, we just can't, it has no, where a person's race, religion, sex, national origin, sexual orientation, age, disabilities. Well, I'm not going to go to disability because that's this case, but you know what I mean? You can come up with a sentence or two that you want the court to read in a innocuous aspect at the very beginning when I give my generalized about the court trial process, right? And that might assist you all. It's not a requirement. I'm trying to ballpark some ideas that might assist you because I'm hearing what you're saying.
Well, I had an idea,
Sure.
and I was thinking of giving him a no-no list card, just a little card like a baseball card with no, you can't do this, like no mention of Russians, no talking about the bankrupt, things like that, all right? But I think Mr. Odou is exactly right. It doesn't matter what kind of list I give him or what the court says. This guy's told the story for years, decades about the Russian, we're not going to pull that out of his.
Which is why this court was wondering, would it meet the needs of all the parties, potentially, is if you all worked a sentence or two that the court gave to the jury in its beginning instructions, you may hear some of these things. And you may hear a person refer to someone by their age or race or things like that.
Yeah, I think it would probably be more effective to do it right after his testimony if there is some.
I don't care when. I'm just saying, if you all wish something like that, if you think it's necessary, I can incorporate that into my ruling that the parties, if any party requests that I do it, then the parties would have to come up with some joint statement.
I think when Terrible Herbst hears the actual testimony, that they will conclude that they shouldn't, this is not that big of a deal that should be accentuated, but.
Okay, so let me hear Terrible Herbst's position. Counsel, you get last word. Go ahead on behalf of Terrible Herbst.
Yes, as you know, we weren't involved in the last trial, so at least myself, I wasn't present and I wasn't able to hear his live testimony. We're not opposed to having some sort of write-up that you're talking about that goes to the jury. Certain things may be mentioned, but should be disregarded. Also, last week we had discussed the possibility of disclosing his testimony via deposition, which we would also welcome comments from the other parties, and we would be open to that as opposed to having him in person on the stand. As mentioned last week, his health has declined. It is unknown as to whether his story has since changed or what he will be speaking to if he is live, and so we would also be open to using his deposition testimony.
I'd rather have him live, Your Honor. But
The court can't preclude someone prospectively on some anticipatory aspect that he may say something in a particular way. I mean, realistically, what the court is going to do here is I'm going to do as follows. Terrible Herbst motion eliminated number 8 to exclude references to the Russians. I'm going to grant it in part, deny it in part, and defer it in part. Okay? It's granted in that I'm going to require that parties and their witnesses remind witnesses not to utilize somebody's nationality as it has no reference or relevance to this case. Okay? However, realizing the statements made by counsel that sometimes people might inadvertently still say something if they've, quote, told a story for a long time, I'm denying it that somehow if it's only as to Mr. Marlowe, not anybody else, that if it's only Mr. Marlowe, if he says it as part of his background as to where he got titanium tubes, I am going to deny that as being it's a hard way to say this one because I'm going to consider how it's said to see whether or not there needs to be a curative if it happens, and if there needs to be a curative, what I will do is I will ask the parties if they want to either come to bench or whether we're taking a break, depending on where that is. And if any party requests a curative, then I'm going to tell you in advance, I'm going to ask the parties, and that's not an advisory ruling, it's part of today's ruling, because you all have said that this is an issue that is intended on good faith belief, at least by two counsel, may come up, that you all work together on a prospective curative that I can tell the jury. If nobody requests any curative, I'm going to view it as waived. I think that meets the needs of everyone. I think it takes into account the realities of the situation. It minimizes any prejudicial impact, but at the same time, it doesn't go into speculation on what somebody may or may not say, which we don't know yet. I'm not going to require somebody to appear via deposition because I've not heard any legal clause on how this court should do so, because there's been no actions, there's been no violations, there's been nothing obstructive or anything in this court that would have any reason for this court to do so, nor has anybody indicated that it's anything other than somebody who maybe at a certain stage of their life might inadvertently say a particular word even after being cautioned not to do so. Counsel for Chairman Herbst, does that meet your needs? Or are you requesting something different?
No, it meets our needs, Your Honor. I just mentioned, possibly using his deposition because we discussed it last week, but that meets our needs.
Okay. And I'm not in any way prospectively saying if somebody chooses to use a deposition, you've got a date by which you should have already done your designations, and I'll be hearing them on the 27th, and I can't prospectively know if anybody's going to have any emergency between now and then. So you understand, I'm not precluding and I'm just not requiring at this juncture.
Yep.
Real water, does that meet your needs?
Yes, Your Honor, Joel, I do, thank you.
Plaintiffs, does that meet your needs?
Yes, Your Honor. And we already provided the designation for Mr. Marlowe, I believe, on Friday.
Right. I understand, yeah.
Just out of an abundance of caution, we did do his designation.
Okay. And do your since I've not had a chance yet to see them, does your designations include the word Russians?
Well,
It
it has
may.
to, Your Honor, because you can't just pull it out of his.
Okay. So then what the court will do is if it ends up having to have a need, I'm going to address the issue about the depot designation when we address depot designations in general and see if the parties have a suggested curative if we end up going that route. I think that makes more sense to do those all together rather than sidestepping today into partial designation on something I haven't yet seen. Okay? That takes care of that part. Document 647, Chairman Herbst, motion eliminating number 9 to exclude arguments Ray rocket fuel. Court's going to have a question here because this is only phrased as to the words arguments. It's actually not phrased, but yet the body of it seems to say that there's going to be no reference or testimony how hydrazine would be used, etc. So court's going to have a question about clarification on the scope and breadth of this motion. Is it seeking to preclude the term rocket fuel at all in a factual basis, or that somehow there was intent to put rocket fuel in water? So I need counsels for Chairman Herbst. Would you mind, in light of where we are today with all the different matters that have already been resolved and where the claims and defenses are today, just give that clarification when you give your analysis on motion eliminating number 9. Go ahead, please.
Yes, Your Honor. To address your question that you just asked, we would move to have the term referring to hydrazine as rocket fuel, as it has been throughout these proceedings, altogether. If not, we would excuse me, pardon me, we would ask that the term would be limited in the alternative to only in discussions when talking about its other uses. But our initial argument is that the term rocket fuel should not be used when referring to hydrazine because it's not relevant. The hydrazine intentionally created for use as rocket propellant has no association to the hydrazine detected in certain real water samples, which was unintentionally produced during the process real water used to negatively charge its alkaline mineral concentrate. As you point out, when we're discussing the differences between intentionality and whether it be unintentional, although hydrazine was detected in real water, it was not the result of any association with a rocket propellant. These references are highly prejudicial, and they'll be used as such. References to rocket fuel impliedly suggest to the jury that real water was contaminated with actual rocket fuel. As we know, this hydrazine in a rocket propellant includes far more chemical compounds than just hydrazine itself. And it is intentionally created and produced in those situations to be used for a specific and intended purpose. This implied mischaracterization, equating hydrazine found in real water to hydrazine that is intentionally created to be used by jets and rockets. They have no relation in this case. And plaintiffs, they reference in their briefs other decisions that have discussed hydrazine specifically and referred to it as rocket fuel, but in those cases, they directly relate to rocket fuel. These are ground chemical plant cases that make specific references to rocket fuel because that is what is going on. One is an explosive manufacturer, another is a developer and tester of the titanium missile system, and another is a chemical plant that is making specific fuel for the Air Force. In these cases, the hydrazine being discussed specifically relates to rocket fuel here, because real water unintentionally produced hydrogen and it was detected in certain samples. There's no relation here to the type of rocket fuel or to the type of hydrogen that the plaintiffs are referring to. So yeah, we are looking at an intentionality versus an unintentional situation, and because of that, if it is allowed, it will be very prejudicial if the jury hears that, as we all know that you should not drink any fuel, and allowing that would definitely taint terrible Herbst. And for those reasons, we ask that you grant this motion. And if you have any questions, feel free to ask. I'll reserve time after the others discuss this as well. Thanks.
Actually, I didn't, well, it seems to me I'm doing both 9 and 6 together, right? Because Real Water's motion eliminating number 6 was hydrogen as rocket fuel as well. So let
That was my understanding. We
Real
joined
Water.
their motion and ours is very similar, if not the
So
same.
I see you both standing up. That's the reason why I was going, I'm going to go next to Real Water, because since both parties are requesting rocket fuel be excluded, I should combine, as we talked about on Friday, Terrible Herbst number 9 with Real Waters number 6, which the first one was document 647, and Real Waters was document 614. Go ahead, counsel for Real Water.
Well, we join in Terrible Herbst's motion, and to add, not to duplicate that, but to add on to it, it's not disputed that hydrazine can be used in the production of rocket fuel. And plaintiff can't explain what hydrazine is, how it's toxic, what it is. They can state that hydrazine can be used in the production of rocket fuel. That's the truth. That's the reality of the situation. But that is not their intent. Their intent is to distort reality, distort the truth by saying at every opportunity that that Real Water put rocket fuel in the water, that rocket fuel is in real water, and that's untrue. It's inflammatory. Hydrazine was found in real water. Rocket fuel was not found in real water. The FDA tested real water and found hydrazine. They did not say they found rocket fuel. And to allow plaintiffs to make rocket fuel their theme is misleading, irrelevant, inappropriate, prejudicial. It's hydrazine is an inorganic chemical. It is not rocket fuel. And so while it can't be say, hey, they can't even mention it at all. Hydrazine is in a lot of different products, and if part of their explanation is that one of the products that it could be used in is rocket fuel.
Are you saying hydrazine is in any product that's available for consumption of people?
It's in a lot of different products. It's in medication. We're not trying to make the argument that one example that was brought up before is that it's in an anti-cancer drug, and so no one's going to go and say hydrazine was put into real water to make it an anti-cancer product. And so, they can use the hydrazine. Plaintiff can say hydrazine is toxic. Hydrazine is a substance that is used in the production of rocket fuel. It should not be consumed by humans. They can say that, but at every opportunity to go around and say real water put rocket fuel in their product, it makes them sound like they did it on purpose, or that somehow, even though it was inadvertent, a jury could say, well, why would they even have rocket fuel around an area where they're making water? It could be totally misleading. It was an inadvertently created when they were making real water. Rocket fuel did not go into the water. It was hydrazine. And for them to walk around the entire time, rocket fuel, rocket fuel, rocket fuel, it's misleading because it's not rocket fuel. That's not what the FDA found. There's no reason to use the term rocket fuel outside of the explanation is to inflame a jury to paint the picture that real water are bad people, or somehow they had rocket fuel around when they were making water. and that's just inappropriate. Thank you.
Okay, appreciate it. Okay, so you each had a chance, so you had a joint opposition. Go ahead, counsel.
You know, 110 years ago, Gertrude Stein wrote a poem that I think is appropriate. A rose is a rose is a rose. That was in a poem called Sacred Emily.
And your partner quoted it in a different case about a month and a half ago. Go ahead.
I know, we're poets back at the office.
Appreciate it.
In any event, that original poem has been corrupted a little bit. Now the common phrase is a rose by any other name. And the same is true of hydrazine. Hydrazine is a rocket fuel. You just can't get around that. Shane, can we have the Wikipedia, please?
Oh, this is,
Thank you.
no worries. Yeah, you quoted it on page
Shane,
one.
Wikipedia says hydrazine. Hydrazine was first used as a component in rocket fuels during World War II. We've agreed to leave all the World War II out of it. We're not even talking about that it's used in a military context. All we have said is it's a rocket fuel. And so Mr. Freeman gets up and he says, it's okay if we say hydrazine is used in the production of rocket fuel, unquote, but we can't use the shorthand of rocket fuel. I don't really see the difference. But anyway, here's the Wikipedia entry. Here's the scientific articles. Rocket fuel, rocket fuel, rocket fuel, rocket fuel, rocket fuel, rocket fuel. They keep saying it over and over again. And I think that has a particular problem in this case because all the toxicity studies that Dr. Kosnick is going to talk about, not all of them, but most of them were done at the instance of the military because they were concerned about the toxicity of this rocket fuel. So all the studies from the 60s and 70s and 80s where they're killing mice and rats and rabbits and guinea pigs and dogs, studying this, all of them use the term rocket fuel. So now we've got to somehow or another neuter our toxicologists too because they think there's a problem. The case law, could I have the case law? All the cases use the term rocket fuel. Every court that's ever discussed hydrazine has called it rocket fuel because that's what it is. So, the suggestion that we should be hamstrung in this case and we can't use the term rocket fuel, and then in the other hydrazine context we can't refer to the Wicked Witch because Satanism. But now in this case, we can't talk about NASA using rocket fuel to launch its hydrazine powered the spacecraft that went to the moon. Okay, so we compare real water to NASA, and that's bad too. I just don't see the reason for this type of straitjacket or handcuff put on plaintiff's counsel. And I think given the ubiquitous nature of the term hydrazine in connection with rocket fuel, Mr. Freeman says that we're going to suggest to the jury that they have a tank of rocket fuel, of hydrazine there, and they're pouring it in intentionally. We're not going to do that. In fact, to the exact opposite. Dr. Najim has this big chart, and he painstakingly goes through how the tubes get double zapped, and that's how the hydrazine. There is no suggestion that this is an add-on that they're intentionally pouring into the product. So if that's the fear, it's totally unfounded, I guess I should say. And, so for those reasons, Your Honor, we don't think there should be any limitation whatsoever on the use of this terminology.
Okay. I'm going to give a last word to both Terrible Herbst and to Real Water since these both motions eliminate 9 for Terrible Herbst and 6 for Real Water. So, Terrible Herbst, would you like to have your final words? And then Real Water will have an opportunity to their final words.
Yes, Your Honor. Trevor Everett for Terrible Herbst. Again, referring to hydrazine as rocket fuel is highly prejudicial. A juror hears that, instantly thinks that, as pointed out, that a jug of actual rocket fuel was taken in to the process, poured into the concentrate, and used. That is just not the case. The stipulation that we've been discussing here specifically indicates that it was unintentionally created, whereas rocket propellant is intentionally created and it has intentional purposes. In fact, the cases cited by plaintiffs' counsel suggests that those cases specifically discuss hydrazine in the context of rocket fuel and rocket fuel causing injuries and damages. Here, that is not what we're discussing in a food safety product liability case. These references are inflammatory. They will do nothing but confuse the jury. And even more so, the amount of hydrazine needed and used in rocket propellant is vastly different than the amount of hydrazine that was detected in certain real water. To say that there is a connection or a similarity is just not the case, and it only be used to paint the defendants in a negative light. And for those reasons, we ask that you grant this motion. Thank you.
Counsel for Real Water, you get last word on your motion number.
Just a couple of points. I didn't try to suggest that plaintiff's counsel would make some suggestion or remark that a bucket of rocket fuel somehow dumped into the water. But the point is, it's not out of the question how a juror could get confused as to how rocket fuel got into water. They can explain hydrazine, and that hydrazine is a component of rocket fuel. But I think all those studies and articles that they put up, they had one common theme, and it was that hydrazine is a component of rocket fuel. Hydrazine is used in the production of rocket fuel. They're two different things. They are not one and the same. And while they can explain that about rocket fuel, to walk around and say that rocket fuel was in the water is untrue. And that's the distinction. Thank you.
Okay, here's the court's ruling. And remember, the court has to look at these and how these motions came before the court. We have motion eliminate number 9, which is terrible Herbst. That was document 647. Terrible Herbst. Motion to exclude arguments, Ray, rocket fuel. And then we have Real Water, which is document 614's motion eliminating number 6 to preclude plaintiff from referring to hydrazine as rocket fuel. Doesn't seem to want to preclude defendants from doing it, but just plaintiffs. Court needs to deny both. And here's the reason why. Remember, the court is not affirmatively saying that misstatements can be made. I have to deal with sophisticated counsel. There's Rule 11. There's candor to the court. There's candor, there's all sorts of rules of professional conduct. Trial has to be done, and counsel know that depending on how they phrase it and what context they phrase things and how many times they phrase things and the potential implications thereof. But the court can't find that there's a legal basis in either the motions in limine that would have this court actually exclude either the arguments as it's phrased in 9 or in 6 to preclude only plaintiff from referring to hydrazine as rocket fuel. So it is so ordered that those are denied without prejudice. The court, however, remember I deferred in part number 659, which was the 2 pictures / videos combined with the Oz one. That's going on Wednesday. So the court's not ruling on those videos, pictures today in this ruling, because I'm addressing those specifically on Wednesday, but the court is denying these motions as far as references, arguments, etc., as set forth in the court's analysis of a few moments ago. It is so ordered. Thank you so very much. Okay. We need to get a nice 15-minute break. Probably people need to stretch their legs, etc. My team needs to. So let's come back at 11:25 and we'll continue on. Thank you so very much.
Thank you, Your Honor.
We good? Nope, wait. We lost Mr. Parker.
I don't think he's on the next couple, Your Honor.
He said.
He's not on the next 6, Your Honor.
You all want me to start or wait?
No, I think he is. Well, actually, he is on the second.
I would ask the judge if you wanted to. We can take him out of order.
Well, that's nice. My whole team did everything corrupted a certain way. That's nice.
One up.
Which would make the next one after that even more quicker. Okay, so let's get on the record. Let's get people off of mute and let's get you taken care of. Okay. So next one we show is document 668, Terrible Herbst motion eliminating number 5 to exclude the criminal history of Real Water employees. And We had Real Waters joined there too. Councilor Real Water, you stood up and said that you might have an agreement.
I think we have an agreement on this one.
Yes, Your Honor. We discussed this and talked to Mr. Odou about it, and we'll agree to withdraw, or we'll agree that we won't reference any of the criminal history matters that the motion seeks to exclude.
Okay. It's actually ET&T. It's actually Terrible Herbst's motion though. Real Water did do a joinder, but did you speak with Terrible Herbst?
Right. I just mentioned it to Mr. Odou. I haven't spoke to Terrible Herbst about it, but we will agree to that motion and won't reference the criminal history of Real Water employees.
Okay, does that meet the needs of Terrible Herbst?
That's
That meet the needs of the joinder party Real Water?
Yes, it does, Your Honor.
Okay, the court need not rule on document 668, motion eliminating number 5 of Terrible Herbst to exclude the criminal history of Real Water employees because the stated won't be mentioned and there's an agreement between the parties. Okay, so now we're going to go to...
Your Honor, I'm sorry if I can. We are also willing to agree to document 682 ETT mill.
I wait till I get there, please. We have an order, right? You all have modified enough times. Let's please keep our order so that wonderful team have got things put in. Appreciate it, but we'll get it one by one. Give us just a quick second. Okay. So we already did 688. It's moot. Agreed. Going to document 679, Terrible Herbst, motion limited number 7, to exclude Real Water's interactions with OSHA. And that has a Real Water joinder, which is document 719, plaintiff's op 832. Terrible Herbst's reply there to 947. And counsel, this was not the one you had an agreement to, right?
I'm sorry, say that again, Your Honor?
This one needs to be heard, correct?
It does.
Okay.
Your Honor. I think you kind of ruled
Court's
a part of it.
inclination is consistent with what I said the other couple of days with regards to OSHA, but counsels feel free to set forth, Terrible Herbst, what's left that you'd like the court to rule on. Go ahead, please.
Thank you, Your Honor. Trevor Everett on behalf of Terrible Herbst. Yes, we've so specifically discussed prior to today was the citations themselves. This motion also seeks to preclude any discussions with particularly Nevada OSHA or OSHA relating to any potential violations. There was a lot of back and forth in the time period of late 2016, early 2017 regarding some OSHA compliance issues with Real Water. I believe these are not. They, whether or not cords was on the floor or certain procedures or manuals were not open in plain sight, or whatever these OSHA references were made at the time, or not, they have no bearing on Mr. Hunwardsen's claims in 2019. They're not relevant. Even if they were relevant, the probative value would definitely be outweighed by the unfair prejudice. It would confuse the jury into thinking that whether or not they see these conversations, but if they did see these conversations and communications, they would tend to think that, oh, if they were potentially violating an OSHA code, maybe they created a bad product. And that is something that we shouldn't get into, that we do not need to get into. They were several years before Mr. Hunwardsen's injuries, and they have no bearing on the outcome of this case. And for that reason, we ask that the motion be granted.
Okay, just a second. I got Real Water's joinder there too, so let me get Real Water first if they wish anything substantive.
Nothing to add on behalf of Real Water, Joul, I do. Thank you, Your Honor.
Okay, thank you. Now, counsel for plaintiffs, go ahead, please.
Thank you, Your Honor. Now, I believe the court's already ruled on this. I think based upon the prior decision regarding the OSHA consent decree, that the court has already indicated that the interactions between the OSHA and the Real Water employees would come in. In fact, by way of example, the OSHA investigation, the EIR reports from the CDC, the involvement of Southern Nevada Health District, the court said all of those things were fair game. And again, Your Honor, this ET&T motion seems somewhat hypocritical when you consider ETT's opposition to our motion limiting number 16. Your Honor, I think it's clear that the OSHA investigations, the findings that Patricia Converse was able to discuss are all relevant in terms of how this Real Water facility was maintained. In fact, the lack of quality control was discussed quite a bit by Ms. Converse. The failures of the shifts to do inspections. I mean, the record's replete with issues supporting OSHA's involvement with the investigation of this facility, and it is all relevant to where we are in the facts, the plaintiff's claims, and that will be presented to this jury. Again, Your Honor, I don't see that there's anything left to argue, given what the court has already indicated previously. I think that was last Wednesday or Thursday, Your Honor. Does the court have any questions about this at all?
Can you refresh the court's recollection? Is Ms. Converse live or depo?
Oh, Your Honor, she was deposed, but I also believe, I can't recall if we brought her in live or we played her video deposition during the trial.
Judge, she was the one that I tried to depose, and we sent the process server out 3 or 4 times, and we could never get her, but we're going to try to bring her live.
Okay,
it was by depo, and I would guess if she was ducking service last time, I can't imagine she won't try it this time.
She was the one who, Your Honor, was the receptionist for about a month or so, and then
6 weeks, wasn't it?
elevated to quality control director. And then she also testified that there was no quality control director before her. Your Honor, certainly I can understand why ETT does not want this testimony out there, but it is the facts of this case. It's very relevant. And simply because it's harmful, their case doesn't make it inadmissible under 48.035.
Thank you so very much.
Thank you, Your Honor.
Okay, last word by Trevor Herbst.
Honor, these communications, when viewed as a whole, they are prejudicial. These OSHA communications relate strictly to employee health and safety. It shows that they had employee health and safety issues and that they were working to rectify these issues at the time. Several of these issues related to procedures and manuals and policies that needed to be in place, or that needed to be, a poster on the wall that listed out what happens if you get burned and how you wash out your eyes and whatnot. They're procedural issues that are being discussed back and forth, and those issues regarding employee health and safety, they aren't relevant to the claims here, and if they are, they're marginal value and would work to confuse the jury and to make an assumption based off of OSHA requirements, and they could conclude because OSHA requirements aren't being followed, potentially, because these are emails back and forth, then a product was tainted and it caused injuries. See, there's a disconnect there, and for those reasons, we would ask that this motion be granted. Thank you, Your Honor. I'm going
to tell you what the court's inclination is. I'm going to give you a minute if anyone needs an additional minute of argument. Here's where the court's inclined to do. The court's inclined with Trevor Herbst motion eliminating number 7 is to deny it subject to the court making individualized determinations at the time of depot designations for purposes if she comes in via deposition. If she comes in live, then my ruling would be subject to a question by question objections during her testimony. That's the court's inclination because I don't see it's a basis for exclusion, particularly some of the arguments with regards to inconsistencies, etc. I really think those need to be addressed. If it's depot, statement by statement at depot designation, and if she ends up coming in live, it's addressing the scope therein consistent with the depot designations discussion if she ends up coming in live. That's the court's inclination. I'm going to ask counsel for plaintiffs first if they want to, because I want to make sure that the moving party gets last word. Counsel for plaintiffs, do you need to be further heard?
No, Your Honor. Thank you very much.
Real Water, do you need to be further heard?
No, Your Honor. Thank you.
Counsel for Trevor Herbst, do you need to be further heard on that?
Thank you.
Okay, court turns what it stated its most recent inclination into an order. It is so ordered, so it's denied with the caveat that the ruling does not preclude the court from doing a basically designation by designation analysis for depositions, and then if I have to revisit if she comes in live, then I need to do that. So, moving on to the next one, I think, Counselor, Mr. Pepperman, I think you're about to say something about the next one. Casey Aiken, Trevor Herbst, motion eliminated 18 to exclude references to Casey Aiken working at a strip club.
Yes, Your Honor, we'll agree to withdraw our opposition to this one as well, and we'll not make any references related to Mr. Aiken working at a strip club.
Counselor Trevor Herbst, does that meet your needs?
Does, Your Honor. Thank you.
Bill Water, do you have a position here?
We appreciate plaintiff's position that they're not going to offer the evidence.
Okay, so then the court need not rule on document 682, Trevor Herbst motion eliminating number 18, since the opposition's been withdrawn, and there will not be any references to Casey Aiken working at a strip club. Okay. So, counsels, I do see that finished off what we showed for today before the lunch hour. But here's my question. There's
only 4 left, Your Honor.
That's where my question's going, other than the one specifically set aside for Wednesday. So, and when you say 4 left, yes. So the court's prep for them if you want them today, but since I told the parties it was Wednesday, if you want to wait till Wednesday, it's a matter of whether you want to get things taken care of now or if you want to have more things on your Wednesday.
Your Honor, I'm going to have a request regarding Wednesday, so I'd like to get more done today, if possible.
Your Honor, Joul,
The next 3 motions are all plaintiffs. So, Counsel for Real Water, you okay? Or not? I don't want anyone to feel like they have to do it today. Like I said, I'm offering you either option because initial expectation was Wednesday.
Joul Odou for Real Water. We're prepared to proceed on all 4.
Carol Herbst?
Your Honor, I have 637 and 688, and we can go forward with those. I'm not sure about what comes after that.
Oh, sure.
My co-counsel that's sick may be addressing.
Okay, well, let's get these first 2 taken. It's the marijuana consumption and future lost earnings.
Right. Those are mine. So that's...
Well, let's get the next 2 and then we'll check back so it gives everyone a chance if they want to say wait till Wednesday on the last 2, okay?
Sounds great, Your Honor.
Does that seem fair? Because you said the next 2, right, are good?
Well, I think actually the next 2 are marijuana consumption and future.
So the next 2 are, okay.
That's right.
Let me be clear what the next 2 are so that everybody understands depending on what listing you're looking at. Okay, what the court shows is the next one, which originally was going to be Wednesday, but the court's perfectly fine doing it today, is document 637, plaintiff's motion eliminating number 9 to pre-admit the standard life expectancy table for Myles, Hunwardsen, and relatives. And then the one after that was document 688, plaintiff's motion eliminating number 30 to pre-admit the video of Myles Hunwardsen in the hospital. Are you good to have those today, or do you want to wait till Wednesday? Counsel for Trevor
I'm good on those.
For today?
Yes.
Okay.
Thank
So we'll stay tuned on the other 2 after we get through these and see where you wanted to go next. Counsel for plaintiff. Motion eliminating number 9. The court's inclined to grant it. With regards to Myles Hunwardsen, I need a little bit more of an analysis on why relatives, you're asking for the life expectancy table on the relatives for purposes of what you're needing here, fully appreciating the mom, etc. But that's the court's inclination. Go ahead, please.
Yes, Your Honor, I think that the life expectancy of Myles is relevant. The plaintiff and defense medical experts both agree that his life expectancy has been significantly shortened as a result of his liver transplant. Real Water's medical expert, Dr. Alcina, opines that Myles, more likely than not, will not meet the median life expectancy after a liver transplant, which is 15 years. Or he will live about the median life expectancy, which is about 15 years. Also, the need for future medical care is undisputed, so we need to be able to determine, an idea of life expectancy for the purposes of future medical care. The U.S. Department of Health and Human Services standard mortality tables are evidence of a person's life expectancy because they are statistics of the general U.S. population. In terms of Myles's ancestors, we submit that is also evidence related to his potential life expectancy because those are the statistics related to his actual family members. I should clarify that in terms of pre-admitting any document, we seek to pre-admit the life expectancy tables, but with respect to the age of Myles's ancestors, that's information that he's going to testify to. So we just wanted to bring it up to make sure that there are no issues with that, and if there are, we could address them early. But the main reason for the family members is we just think that's statistical information related to his family and his life expectancy of his direct ancestors.
But raised in the opposition by Real Water, right? And they say that the life care planner didn't take into account the grandparents and the other aspects. So how would that not be something new? I mean, coming in for the first time in trial, or do you disagree? Maybe you think that he did.
Well, the life care planner and even the medical experts' opinions regarding shortened life expectancy, that is what their opinions relate to. They're making those opinions based on how long they think or expect Myles to live. But the reason for the ancestors and the standard mortality tables is how long would he have lived if he hadn't undergone this liver transplant? And so their experts aren't really opining on that. The evidence to show that are things like the U.S. Department of Health and Human Services mortality tables and evidence such as, well, his grandparents are alive at this age and family members live this long. So that's the relevance of that. The experts aren't relying on that. It doesn't implicate that.
But who's the tie-in to say that the age of the grandparents has any relevance to anything with regards to Mr. Hunwardsen for purposes of this case, right? Not a good example, but similar to what you argued against the Nevada beverages employees that drank the real water, right? I mean, didn't get sick. I mean, is there anything that ties in the grandparents with regards to any fact and evidence that's been disclosed in this case? I mean, who's going to tie in the fact if his grandparents lived to 100 or his grandparents lived to 22? That example, because they lived to 22, they wouldn't probably be grandparents, but it's okay. Let's make it 42 or 52.
Well, Your Honor, it's the statistical evidence of his family members on how long they lived, similar to the statistical evidence of that
ties into what, though? Does it tie into? Who's tied it into what to make it relevant for this case?
Well, it's relevant because it's evidence of his life expectancy. The evidence of life expectancy, how long someone can expect to live, is based on...
Who's going to say that? Who's going to say that his grandparents living to X age is relevant to what Myles Hunwardsen versus that being an argument? Do you have some witnesses going to say it?
We just have Myles's testimony that my grandparents lived to the ages that they currently are.
Okay, I appreciate it. Thanks so much. Okay, I've got oppositions. So we now have Real Waters was document 811. Go ahead, please.
Thank you, Your Honor. Joul Odou on behalf of Real Water. The court's hit the issue right on the head. There is no witness that's going to testify or tie in the grandparents, their lifestyles, the mom to these life expectancy tables. There's very real danger of confusion to the jury here. We are very concerned about a prejudicial argument about the damages or the emotional trauma the grandparents and parent are obviously going to suffer by having, and this would be true of anybody, right? If you've got a close relative, if you've got a child or you've got a grandchild who has had a liver transplant, absolutely that's very difficult for family members. But then that leads to the argument that they're not plaintiffs here, and the jury shouldn't be awarding sympathy damages based on the pain or anguish that the mother feels or the pain and anguish that the grandparents feel. This is not a wrongful death case, and admitting life expectancy tables of relatives in this case would be improper and prejudicial. They're not plaintiffs in this case. There's no expert tie-in, and to have that type of prejudicial evidence offered simply to inflame the passions of the jury and magnify a compensatory damage award is improper, and that's why we've objected to it.
Okay, have the first prong, because remember he has two prongs. One is his pre-admission on Mr. Hunwardsen's own life expectancy table, and then the relatives issue. Did you want to address the
We
first part?
recognize that Myles Hunwardsen's life expectancy table is likely to be admitted. We argued that it wasn't tied in because, again, the life care person didn't. It was really both. It was odd that to us that the plaintiffs have not provided an economist or somebody who's going to do present value of the future care. Maybe that'll be an objection later at trial, but instead we have fairly vague testimony about his future damages, his life expectancy, and try to backdoor it through a pre-admission of a table. We've objected to it because there's no expert to say, okay, Myles Hunwardsen is presently 29, 30 years old. He's going to live for another X years. Here's his damages. There's no expert that ties it all together and puts a bow on it in front of the jury and says, because he has a liver transplant, he's only going to live to X, and here's his damages because of that. It kind of starts to trail off after the agreement amongst medical professionals that typically people with liver transplants do not have a full life expectancy. And that's where our objection comes in, because somebody should have provided an expert opinion as to that exact number, and then somebody further should have provided an expert opinion as to what those damages are. And as the court will see once we get to trial, I'm kind of getting ahead of myself. That piece of evidence will be missing.
Stay tuned for Real Waters Motion Eliminating number 11.
Yes.
This part. Okay. Appreciate it. Counsel for Trevor Herbst, who's doing this one? Go ahead, please.
Yes, Judge. In addition to the lack of expert testimony on the genealogy, the exhibit that we understood plaintiffs were seeking a pre-admission of, and it doesn't appear like that's the case anymore, it lacks, foundation. If the plaintiffs wanted to introduce this type of evidence, they should have supported it by birth and death certificates. And so that proffer would be inadmissible.
Okay. Appreciate it. Counsel, you get last word. And if you wouldn't mind just clarifying, I believe you're saying pre-admission on life expectancy table, and then what you're actually seeking to include or exclude with regards to the relatives versus the court addressing that at the time of trial. Go ahead, please.
Yes. In terms of the genealogy, it's just the facts. We just raised the facts as in advance but there's no document related to that. It's just something that Myles Hunwardsen's gonna testify to. In terms of the life mortality tables, yes, we do seek to pre-admit the standard life expectancy tables, which is a pattern jury instruction, which is expressly stated that it's evidence of how long a person is going to live. The life tables are general evidence of that based on statistics. The statistics of the general population. The statistics of Myles's family is specific evidence related to Myles Hunwardsen's genes and ancestral history. There's no expert needed to tie in this evidence of statistics regarding how long someone's going to live. There's no expert who could say you or I are going to live to a certain age. It's all based on general statistics. Statistics of what the average person is going to live to is clear evidence of a person's life expectancy. Statistics related to what the age their family members live to is specific evidence related to a person's life expectancy.
Really? Who's going to say that, though?
Well,
I mean, I'm hearing what you're saying, but I didn't see any support for that.
Well, you don't need an expert to say that someone's statistics is 100% determinative or 10% determinative, and literature provided by Real Water in the opposition. It's a fact to consider, evidence that is probative to if your grandparents lived to a certain age. The argument is that's probative to the late age that someone else could expect to live to, in conjunction with other evidence such as statistics in the general U.S. population. The statistics that are provided in the standard life tables, they have varying ranges. And so the decision on where does Myles Hunwardsen fall within that range is subject to additional supporting evidence. And the jury instruction regarding the standard life expectancy tables specifically contemplates that. It says these numbers are based on the standard mortality tables published by the U.S. Department of Health and Human Services. It's not conclusive. You can consider other evidence, such as evidence of the person's habits, lifestyle, and it lists several other factors.
So you're re-asking marijuana to come back into this case? You're comparing lifestyles. His grandparents do marijuana?
Well, I think that is a separate issue. If there's a basis to say that marijuana were to substantially reduce an average person's life expectancy, I think it would be fair game on something like that. But the point is, in all those other items where the jury instruction says you can consider evidence of their habits, their lifestyle, those types of things, in terms of life expectancy, it's indicating that there's additional things that are relevant, and we respectfully submit that the age of his family members, his direct descendants, has additional probative value to this issue. I would add and close with that the experts in this case, they do give opinions regarding Myles's life expectancy as a result of his liver transplant, because there are statistics related to how long people live after a liver transplant. They base their opinions on the facts and evidence that they reviewed and their experience as liver transplants doctors, seeing, hey, this is how long I typically see someone live after a liver transplant, to come up with those opinions. But those numbers, those expert opinions, which require expert testimony because they're based on someone who's had a liver transplant, needs to be compared against the life expectancy they otherwise would have lived. And for that, Your Honor, there's no expert testimony required. Thank you.
Appreciate it. Document 670, Plaintiff's motion eliminating number 9, granted in part and denied in part. Granted to pre-admit the standard life expectancy table for Myles Hunwardsen, denied in all other respects. It is so ordered for the reasons adopting the arguments in the opposition, particularly as to relevance. Okay, moving on. Document 688, Plaintiff's motion eliminating number 30 to pre-admit the video of Myles Hunwardsen in the hospital. And I have oppositions of Real Water 818, an opposition of Terrible Herbst 831, a reply 955. Go ahead, please do the pre-admission, please.
Yes, Your Honor, I was going to just play a short portion of the video for the court, so the court can see what we're talking about. Jane. As the court can see, it's a short video. It shows Myles in the hospital at UCLA at the time of his liver transplant. It's relevant to show Myles' condition at the time. It's not inflammatory. It's not graphic or gruesome. It's not needlessly cumulative. It's not unfairly prejudicial. There's no dispute that this video shows Myles in the hospital, but we provided the declaration of Myles' mother, Lori Ogilvie, who took the video as further evidence of authenticity. It's not hearsay, it's demonstrative in nature. It's not asserting anything. He's not, pointing and to suggest or assert that something, is there or that there's any type of assertion. And Myles will be available for cross-examination at the time of trial on this video, should there be any, and no other concerns about reliability. So for all those reasons, Your Honor, we'd ask that this video be pre-admitted.
And for what purpose, at what stage of the trial are you without giving up your trial secrets, but let's find an understanding. Is there going to be a foundation laid beforehand? Are you thinking it for opening statements? Because that's part of the issues raised, right? So, would you mind just clarifying that, please?
Yes, Your Honor. We haven't prepared the opening statement slides yet, but I'd anticipate that it's possible that this video would be played in the opening statements to show it. Again, I think this was discussed. I believe that we have a good faith basis to admit this video and would be allowed to play it in the opening. But we file a motion to pre-admit just to avoid any potential issues with it and avoid any time at trial when it comes up and Myles is on the stand, laying any foundation that would need to be laid. But Your Honor, respectfully, I would submit that there is no additional foundation that needs to be laid. We've, submitted the evidence of authenticity. It clearly shows Myles. There's really no dispute to that. It's relevant to his condition at the time, which is the subject of his trial.
Sure, counsel. My only question was the timing.
Yes, Your Honor.
No worries, thanks. I just need to give everyone an opportunity time, right, to speak. So, thank you so very much. Appreciate it. Okay, Real Water, you have an opposition. Yours is lower in number, so feel free to go next.
Thank you, Your Honor. Joul on behalf of Real Water. When we initially got this motion, there was a collection of 4 videos that appeared they're trying to admit, and we had objected to all of them. In hearing counsel's argument, it sounds like it's just the one video now. So I'll, if it's more than one, I'd like to respond to the other, because there's different reasons some of those other videos are objectionable, but I think it's just the one.
So let's, counsel, get a point of clarification. Is it just the one video, or is it 4 videos, or?
No, this motion relates to just the one video.
Can we identify the video? Are you calling it something, or a date or something? What's your titling of it? Just make sure everyone's literally on the same page.
Like, call it the post-surgery video.
It's page number Hunwardsen M01329.
329. Okay, so that's the only video at issue. Is that correct?
In this motion, Your Honor, I just want to make sure we're not waiving the right to seek to admit any additional videos or photographs, but those aren't the subject of this motion.
Appreciate the clarification.
Sure.
Yeah, we're only opposing then for this motion. Again, this would be played, prior to testimony, so there's not going to be a foundation laid, and for that basis, we think it's unfairly prejudicial. The foundation is going to be laid for the video by plaintiff's opening argument. Here is Mr. Hunwardsen post-surgery. Here is the difficulties he's going on, and it really starts to go into argument rather than fact. So we had objected to the pre-admission. Now, if the court admits it and they make argument, of course, we would still have those objections.
Okay, let's walk through. It appears that foundation you think is going to be laid, right?
Right.
Authenticity didn't seem to be challenged by Real Water, that it's edited or anything like that, or it's not the actual video, or it's not him. Okay. So then the third argument kind of was the prejudicial component.
Effect of the
So
video.
the timing of pre-admission versus if there's going to be authenticity.
Yes, Your
and
Honor.
foundation. Can you walk me through your argument there, please?
Yes, Your Honor. So it's prejudicial because of what it is, right? It's prejudicial because it's a photo of Mr. Hunwardsen, struggling to walk in the hallway. We don't know when it was taken. That type of prejudice can be somewhat eliminated or reduced by having the foundation laid as to when the video was taken. So by having it pre-admitted and having it played in opening, we don't get that foundation. All we get is whatever spin that plaintiffs choose to put on that video in their opening argument. And that's a different kind of prejudice in that effect.
But if they have a good faith belief
It'll come into evidence.
that it'll come into evidence, if have they already presented it, I understood for purposes of disclosures, it's already been presented with dates and times, right? That's not an issue, because that's in the declaration of the mom.
That's right.
Okay, no, appreciate it, thank you.
Yeah, that's our objection, Your Honor.
Appreciate it, thanks so much. Counsel for Trevor Herbst, who's taking this one? I believe since you said this one was okay, you're taking it, counsel? Go ahead.
We don't have much to add, Your Honor. Where the video lacks relevance is Real Water has now conceded to liability, and the fact that Mr. Hunwardsen had a liver transplant is not in dispute.
But you haven't admitted liability, right?
No.
Well, I guess liability is or is not in dispute. If you haven't conceded liability, then arguing that Real Water's concession of liability makes this not relevant when you're still arguing liability. When I say you're, I mean Trevor Herbst.
Mm-hmm.
Okay, I appreciate it. Thank you. Counsel for Plaintiff, you get last word if you want it.
No, I would just say that it's relevant because it goes to damages. It shows his condition. Nothing I'd have to add.
And you have a good faith belief, correct? You state that in your pleadings.
Yes, Your Honor.
Yeah, the court's going to grant plaintiff's motion eliminating number 30 to pre-admit video bait stamp M01329. Did I get that number correct? Make sure we're...
One more time, Your Honor.
688.
I thought you said bait stamp number was M01329.
Yes, Your Honor.
Okay, everyone agrees. Court's going to find to pre-admit that video only, yes, so grants document 688, which is plaintiff's motion eliminating number 30. The reason why I was giving you the specific bait stamp number is because of the distinction between 4 videos versus the 1 video. That's the one at issue for today's purposes. That's the one the court is granting the pre-admission with all the standards that have been articulated both in oral argument and in the pleadings adopting those. The court finds there's appropriate basis to pre-admit that. Okay, so we have a couple choices. It's 12:05. If you think the next 2 ones are going to get done by 12:15, I can keep my team. If you really think it's going to be longer than that, then in fairness, I could either lunch break and have you all come back for 2 more instead of doing it Wednesday, or we put them to Wednesday. So,
Judge, I thought we had an issue as to whether Trevor Herbst was prepared.
right, that's why I need to check with Terrible Herbst. But I was giving that other caveat because if you all are thinking it's going to take longer time-wise, I have a lunch hour issue, right, for when we started. But we didn't start till 9. We took a break, so we got about 15 minutes to play with.
Your Honor, 657, I believe, will be quick. That's
Counsel,
just a marijuana consumption.
Terrible Herbst, are you okay to do 6:57 or not?
Valerie Rojas is on motion. Should be.
Ms. Rojas? Once again, not trying to put you on the spot. If you want me to wait till Wednesday, I'll wait till Wednesday because it was originally set up for Wednesday. If you want to do it today, we'll do it today.
That's actually Trevor Everett, but we have no objection to the court hearing the room.
Okay, so no objection. Let's continue on then. So document 657, plaintiff's motion eliminating number 27 to include reference to plaintiff Myles Hunwardsen's marijuana consumption.
Afternoon, Your Honor. Can you hear me all right? I had some technical issues there for a second.
I can hear you okay, but I heard Ms. Rojas say it was fine, and since it was plaintiff's motion, I was going to let plaintiff speak first on his motion, okay?
Okay.
Is that correct? Is there some reason we should not be moving forward, counsel?
No, that
You just cut in and out. We may have a different technology issue, but let's see when we get to an opposition. So plaintiff's counsel, I'll let you go first. We'll see if we have a technology issue. If we have a technology issue, then that might be a different challenge, but okay. Plaintiff's motion eliminated 27 to include reference to plaintiff Myles Hunwardsen's marijuana consumption. Go ahead, counsel for plaintiff.
Thank you, Your Honor. I would note first that Real Water has not filed any opposition to this motion, likely because Myles' use of marijuana is not relevant. The dirty dab theory was excluded. There's no expert who opines that marijuana is probative to causation or any conceivable fact of consequence in this case. Even assuming some hypothetical marginal probative value, which we submit there is none, it would be substantially outweighed by the risk of unfair prejudice. While I do believe that fewer people view marijuana use negatively, there's still, I believe, a large number of people out there who do. People with this viewpoint may be on the jury, and the only value of Terrible Herbst referencing marijuana use would be its hope that jurors will look unfavorably on Myles and decide the issues in this case, not on the relevant facts, expert testimony, or other evidence, but based on subjective beliefs about marijuana use. So for those reasons, we'd ask that it be excluded, Your Honor.
Okay, thank you. Counsel for Terrible Herbst, you oppose this, and your opposition was document 842. Go ahead, please.
Thank you, Your Honor. Trevor Everett on behalf of Terrible Herbst. We would disagree with plaintiff's counsel. We do think that this evidence is relevant. It's, as discussed previously with Your Honor, regarding the life expectancy and the lifestyle, his marijuana use, it does go toward and is relevant to certain damages that will be considered: medical treatment, future pain, loss of enjoyment, future mental suffering, and life expectancy. There's the record indicates that he was asked to stop using certain substances, and in August 2020, almost a year after his liver transplant surgery, he started using marijuana again. And these references and his use should be permitted and allowed because it is relevant to his claims that he's making. He seems to be doing quite well, which is a very good thing, and it should be allowed to be, the jury should be permitted to know this. And as pointed out by plaintiff's counsel, this is relevant to, plaintiff's counsel did not say it's relevant. We contest that we say it is relevant because it does go toward these things, because it goes toward the things that they are saying it is not relevant for it, but it is. As he noted, some people think it is. It may affect health. Some people may say it doesn't. Some people view it negatively. Some people view it positively. We do have an expert, regardless of causation. We know that Your Honor's ruling on that, but we still do have an expert that discusses the effects of marijuana consumption and how it can be dangerous and how it can affect a person generally if marijuana includes certain toxins. For those reasons, we would ask that this evidence be allowed. Thank you, Your Honor.
Counsel, I need a point of clarification, please. When you said if it contains certain toxins, are you saying that you have an expert who's going to testify that the impact of his actual marijuana use impacted his life expectancy or something for purposes of damages? Can you just clarify what you meant by that, please, counsel?
So Dr. Atchison's opinion generally is that marijuana can be harmful. Now, we can't use that toward the dirty dab theory and saying that it causes injuries, but he still opines that marijuana use can be harmful, and that is his expert opinion, and that is what I'm referencing there, Your Honor.
Okay. Well, the court already ruled right. Williams Morris got up with the aspect of the prior motion with the dirty dab. It's not alternative causation. So you said it comes in for life expectancy table. So you're saying you've got your expert's going to say it reduces life expectancy, has an impact on mortality or something?
Well, he does specifically state that it can be dangerous when used, and it can affect an end user with respect to their overall health. He doesn't have a specific, I'm not going to sit here today and tell you because he doesn't say that it will have a shorter life, but it can affect the outcomes in one's life if they use it, because it includes certain substances that can harm a user.
Wait, I'm trying to go from generic here, right, to specific. Are you saying that there's actual testimony that impacts Mr. Hunwardsen in this case, or just a generalized statement if somebody buys illegal marijuana that is, I think what the other day you all said, next to a cornfield or something, and the winds blew the chemicals into the cornfield or from the cornfield? I'm just trying to get.
That was a very illustrative example by plaintiff's counsel. Like I said, he does not have an opinion specific to life expectancy, but the effect of the overall use of marijuana here.
Okay, you get last word, Counsel for Plaintiffs. Go ahead, please.
Your Honor, they don't cite to any specific medical expert testimony to establish the relevance of this. Counsel just admitted that it goes back to the dirty dab theory that it could be bad for you if there's toxins in it, can be dangerous. You know, there's no specific tie-in to plaintiff Hunwardsen in this case or on any specific issue in this case. And that's important because we're talking about a balance of probative value versus a risk of unfair prejudice. And what we have here is a clear risk of unfair prejudice, jurors having imposing a negative view and deciding this case on a negative view on marijuana use. That's the risk of the unfair prejudice compared to the probative value of it. And the probative value is non-existent because they don't have any experts saying, how is it relevant to this any issue in the case? How is it relevant to his life expectancy? How is it relevant to damages? You asked them that specific question and counsel could not answer it. All they could say is, well, it could. That's pure speculation. There's no probative value in it. It's not specific. And in light of the risk of unfair prejudice, we ask that this be excluded.
Okay, this is the court's ruling. Document 657, plaintiff's motion eliminating number 27 to preclude reference to plaintiff Myles Hunwardsen's marijuana consumption is granted subject to door opening. And if somebody feels that it addresses the life expectancy damages issue, that offer of proof is going to need to be made outside the presence of the jury to the court. And these, before any questions in that regard would come in, the court can make a determination after hearing testimony. If that's the court's ruling, it is so ordered. Moving on to document 619, Real Water's motion eliminating number 11 to preclude plaintiff Hunwardsen's future lost earnings as speculative, undisclosed opinion. Counsel, and ET&T did a joinder, document 743, plaintiff's opposition 849, and then we have the reply there too is document 950. So, counsel, feel free. I'll tell you the court's going to have a question. It's your Exhibit 8 in your motion where you reference the fact about the undisclosed supplemental opinion. Just wasn't really clear when you were saying, because since you're going for an undisclosed opinion, new opinion, you were arguing it's a new opinion versus a supplement. Just that clarification, which you're probably going to cover anyway.
Yes, Your Honor. Thank you very much. Joel, on behalf of Real Water, exactly. We believe it should have been an initial opinion. You can't just supplement with new opinions and go, oops, here's some new opinions. Specifically, Dr. Hudson's opinions regarding the ability of Myles Hunwardsen to continue working in his current job, to continue working in a different job, or his inability to work. Those all should have been in the initial report. This was a fairly heated issue between the experts as to Myles Hunwardsen's loss of earnings or earnings capacity. In particular, Mr. Uhas for the plaintiffs concluded that basically the argument became, can Mr. Hunwardsen do the current job he's in, which he's doing, or is he untrainable for additional jobs? To make the argument fairly short, Mr. Uhas basically said, there's very little Mr. Hunwardsen could do. His skills aren't transferable, and therefore his damages are X. Our experts said, no, that's not true. His skills are transferable. Here are particular jobs that he could do. And then they run back and say, oh, well, Dr. Hudson says, and that's the problem. Dr. Hudson didn't say. And so it's a supplemental opinion in the guise of what, or should have been an initial opinion that they're trying to now get in the guise of a supplemental opinion.
And how about their statement that it was that even if it did occur, it was remedied quickly and timely during the appropriate closure time periods, and so there's no prejudice under some older case.
Yeah, I'm sorry, Your Honor.
It's their argument. I just want you to address it if you want to.
Yeah, sorry, Your Honor. We had argued there is prejudice because, again, that goes to the whole argument as to whose life care planner is right. And in our life care planner can only take the opinions that were timely disclosed by Dr. Hudson and write a report, not have all his opinions now change because, oh, here's something we didn't tell you. This is a fairly important something they didn't tell us, which is, in Dr. Hudson's view, liver transplant patients shouldn't be in this line of work, and can't continue in this line of work, and there's numerous other lines of work that can't continue because of threats to health. Those are new opinions. Those should have been in the initial opinion.
Okay. I have ET&T, i.e. Terrible Herbst, joined her there too, which was document 743. Do you wish to be heard, Terrible Herbst?
Nothing additional to add, Your Honor.
Appreciate it. Okay, there being nothing additional, then we go to plaintiff's opposition there too.
First, I think there's a little confusion over this. Mr. Odou said that I think he accurately described what the issue is. Our life care planner says, and vocational rehab expert says, there's little skills that Myles has that is going to transition to other job if he can no longer work as an iron worker. Their vocational expert says, I disagree. He can transition to these jobs and make the same amount or more. That is the issue.
But was it in your initial life care planner's initial report saying
Yes.
the fact of that could not transition to other jobs?
Yes. Yes, Your Honor. That opinion was in there. It was disclosed. It was the only thing that wasn't in there initially was he didn't know when that was going to happen, because no one's saying
10 years, et cetera. Okay.
Yeah, no one's saying that Myles isn't going to be able to do any job. But given his significant injuries and the long-term use of these immunosuppressive medications that he has to take to prevent his body from rejecting the transplanted liver, he's going to develop all sorts of problems and future medical issues related to this. He's an iron worker. Works at great heights. He ties rebar. At some point, these medical problems, which are all disclosed by Dr. Hudson in his initial report, are going to prevent him from being able to safely perform that job. And at that point, he's going to have to transition into a different job. And what our expert says is the jobs he can transition to, he's going to not be able to earn the same amount of money, and he's going to have vocational loss of earning damages as a result. Their vocational expert says, no, he's going to be able to transfer into a job making the same amount of money, and there are no vocational damages. That's the issue. It's been properly disclosed. All the experts were deposed on their opinions. They filed a rebuttal report on that issue. This idea that this was somehow not disclosed or not properly brought up is not accurate. And the confusing
Can I stop you for a quick sec? Are you saying in the initial report, which was attached to the motions, that it has a statement of when the transfer may need to occur to a different position?
No,
meaning the 10 versus 30-year argument, 5-year argument. Well, it can't be 5 years because it's already about 4 years post-transplant right now. So 5 is maybe not the best, but 10, 30, et cetera?
No, Your Honor, I'm not suggesting that.
Okay.
Dr. Hudson is not our vocational expert. He opined about the future medical issues that Myles was going to have as a result of his liver transplant and long-term use of immunosuppressant medications.
Did he coordinate with the life care planner so that there's a calculation of when this is supposed to happen for purposes of them to respond?
After the life care planner disclosed his report and said he doesn't have transferable skills, when he's unable to work in his job, he's going to need to transfer to something else, and it's going to have impacts on this. He did not include the time frame in that initial report because he hadn't talked to Dr. Hudson about it.
So he went and consulted with Dr. Hudson, and based on after he got Dr. Hudson's input, based on his own training and experience and expertise, he supplemented his report. I don't remember the exact time. I think it was a few days or maybe a week later, something like that, with the time frame, and said, okay, I disclosed the opinion in the initial report, but now I've consulted with Dr. Hudson and I'm now putting in the time. And so then he disclosed the addendum to his report. After he disclosed his addendum, which said the time that he was based on all his training and experience and his consultation with Dr. Hudson, after that, Real Water disclosed its rebuttal expert reports. They addressed this issue. After they disclosed their rebuttal reports, the experts were all deposed. They deposed our experts on these issues. They asked Dr. Hudson about his consultation with Mr. Uhas. They asked Mr. Uhas about the basis for these opinions. They had their experts deposed. I deposed their experts.
Counsel, I need you to sum it up real quick, just timing wise, unless I can bring this to. Okay.
So, Your Honor, with that, I would just request that the motion be denied.
Okay. Go ahead, Counsel for Real Water.
Thank you, Your Honor. I think the court grasps the issue, and we've already kind of gone over our time. But basically, the problem is that Mr. Uhas and Dr. Hudson should have coordinated before he issues a report. They didn't, and now they're trying to fix that by way of supplement. And that's why we had sought to exclude the new opinions of Dr. Hudson, which weren't disclosed timely, and which Mr. Uhas didn't have, and now he wants to, after the fact, come and try and fix it.
Okay. I was trying to quickly go back through your guys' drives to try and find it. Do you have a chronology time period? I mean, are we talking
I wish I
months,
did.
weeks, or something?
I don't, Your Honor. I apologize.
No worries. Okay, Counsel for Trevor Herbst, you get your last word on, since you did a joiner. Do you need a last word on this? Or?
No, I don't, Your Honor. Thank you, though.
Okay. Look at my ruling on Wednesday on this. I'm going to double check chronology, honestly, folks. I got one issue on this one. So we're going to get my ruling on Wednesday on document 619, which is Real Water's motion eliminate number 11. So put that on my ruling. Okay. So that shows what's up, finished for today. Counsel, Mr. Parker.
I apologize, Your Honor, and if you don't want to hear it, then I understand. And certainly, Mr. Odou and ET&T would have an opportunity to just
But you
reference
understand, I have state and federal law with lunch break. So
I do. The only thing I want to say, since Your Honor is taking this somewhat under advisement, the deposition of Dr. Hudson actually goes into that. And so the issue of surprise, the issue of prejudice, which the court was asking Mr. Pepperman about, I don't know if he specifically addressed it as cogently as the court would want it. And that's the only thing. It's in the deposition, and that's what I was looking, and fortunately we were able to find that Dr. Hudson actually spoke about that during his deposition.
right, and the court has to double check to actually what's actually been presented to the court. That's why I wanted to double check. And I appreciate the heads up, but yeah, I have to check what's in the actual documents presented, which we show is 619, 743, 849, and 950.
Thank you, Your Honor.
Okay,
Thank you, Your Honor.
I appreciate it. Anyone disagree that those are the four documents that I'm looking at? You had a request for Wednesday.
Wednesday, that's it.
I'm going to give you a quick second for that request for Wednesday. Counsel, what are you requesting?
Your Honor, I have a union negotiation issue with too many people that I could not get it changed. Originally, I thought we'd be here Tuesday. Then on Friday, the court gave us the opportunity to move to Wednesday.
It was you all's choice. I
You did. It was not your fault,
actually
Your
was
Honor.
supposed to be here Wednesday and Thursday and Friday. You're supposed to be here all week with.
I know, but we could all tell that we were going to get done sooner. And so that's
what
what
do
I
you
thought.
need, Counsel?
So this is what I need, Your Honor. That meeting is going to take place at 11. Is there any way we could do, say, 8:30 to 10:30, and then I can come back after the lunch period and finish up if there's anything left on Wednesday? I think the meeting will last probably from 11 o'clock to approximately 12:30. So can we have a break during that time period? I don't know if anyone else would be opposed from 10:30 to 1.
What time would you be done in the afternoon?
I should be done, I would think, around
No,
12.
I'm sorry. what time for all these motions to be done, because in light of what you all and where we were with motions, whether I did these extra 4 today or not, you can appreciate the court's plan. Some other things, you're one of the many things on my calendar. So what time do you anticipate you all would be done with the afternoon? Would it be 2 o'clock or sooner?
I would think sometime between 2 and 2:30.
Your Honor, Joul for real water. We don't have a big dog in the motion to strike fight, but based on the argument from the length of argument when these types of motions have come up before, it's usually quite lengthy. It might just be best to start at the court's afternoon session and just go until we're done, like 1 o'clock till done. But
Well, you can't. That's what I'm saying. The court has planned other things in light of you all's representations.
I'm sorry, I didn't hear that.
Yeah, that's why the court was asking Mr. Parker from a totality to be done. For you all, we've got to be done before 3 o'clock.
That's fine, Your Honor.
2:30 or 3 o'clock at the very, very latest, right? Because which was more than reasonable with regards to the few matters that were on. If we're starting, I don't care if we start at 8:30, we can start at 8:30. That's not an issue. I do not have CD matters. We moved that. We moved the CD matter, got taken care of. I can start you at 8:30. That's fine. But if Mr. Parker's accommodation means that you all are going to now need till the 5 o'clock hour, then I can't, because you can appreciate that conflicts with other matters based on you all's time and the few matters we have. Because what the court shows we have is we have 473, 659, part is 619. We have the motion to strike, motion for summary judgment, which I don't have the document numbers real handy quick, right? So we only have 5 or 6 matters that are actually left for Wednesday. I'm not in any way saying they're not beefy matters, but the pure number is not a lot.
We don't foresee a lot of argument on the motion.
I just need straight time frame. So if we start at 8:30, what time do you need to leave, Mr. Parker? And are you taking the arguments that are at issue for Wednesday?
I am taking 2 of the arguments, Your Honor, the motion to strike and the motion for summary judgment.
Well, do you want to do those?
Oh,
first?
and the one we just missed, we moved today, which was number 7, which is the ET&T's motion limiting number 1 to preclude evidence of speculation of admission or liability with real water defendants. So I have that one.
Document 470.
That document number, Your Honor, is
that 473?
Yes, 473. That's correct.
Okay. Well, if we do those first 3 from 8:30, 10:30, is there any reason? Minutes, right? Per things, we should have those way taken care of before the 10:30 hours. Is there any reason not to do those ones first? Because on Wednesday I have not yet set the order on Wednesday. Is there any reason not to?
Done with me, Your Honor.
Well, okay, counsel for real water.
Your Honor, Joul for real water will be here at 8:30, if that's what the ultimate decision, or not decision, the ultimate solution is. We have no argument on what time we start or when we start.
Okay.
We will accommodate Mr. Parker. I will defer to Terribles as to the order of motions or the details, because they have a bigger stake in this argument than I do.
No worries. Once again, like I said, if somebody had anticipated you had another commitment at 8:30 and we were anticipating starting at 9, then I, of course, going to take that into consideration, right? But if I can accommodate one person, nobody has an objection, and we can be here, then that's a different aspect. Counsel for Terrible Herbst, who's doing this? Ms. Rojas, are you taking this one on?
Yes, I am.
Gotcha.
Starting
Go
at
ahead,
8:30.
please.
Starting at 8:30 is fine. With Terrible Herbst, my only suggestion would be that MIL number 1 and it coincides with MSJ number 1. So it might make sense to do those one after the other, or one first, but we can certainly be there at 8:30 and go for however long.
Okay. So let's get some make sure we're all, motion eliminate number 1 is document 473, which was originally Terrible Herbst and Costco's, but now it just would be Terrible Herbst, to exclude evidence in reference to the stipulated admission of liability. Everyone agree that one's on for Wednesday, correct?
That's correct, Your Honor.
Yes, Your Honor.
And then we have plaintiffs' motion for partial summary judgment, which was document 533. which was plaintiff's motion for partial summary judgment as to plaintiff's claim for strict product liability product. That's what you're referencing when you're saying the motion for summary judgment, correct? Which you all have the supplemental briefing, which I don't know if I've gotten courtesy copies yet, but I saw at least one. Like I said, I'm with you all. I'm not checking that right now. So those relate, and then the motion to strike is, give me a document number on that quickly, please, somebody. Because remember, that wasn't on the original letter, so I have to go find it someplace else. Was that 663?
536, I believe.
Someone disagree?
Yeah.
Or someone agree or disagree? Everyone says 536, the motion to strike, right? That was the one that was not originally on the letter that you all added on. Or it should be on, do you still have the disposed program? It might be the bottom of that one. Yes.
Yeah, that was 536.
Okay, so the motion to strike is 536. You want those first three being heard first thing in the morning, correct?
That is correct, Your Honor.
And then afterwards, it would be 659, which is Oz and the rocket video / pictures, correct?
That's correct, Your Honor.
And we have part of, then you get the 619 ruling on the lost earnings, and I'm missing one. Hold on 1 second. There's one more that should be, there's a partly deferred. Did you all get that real quickly? Those are examples. Did y'all show anything else other than those 5? Oh, I'm sorry.
I don't have the equation with your numbers.
2, 3, 4, 5, 6. We're missing one. Okay.
There's
So
685,
is that motion eliminating number?
7.
Yeah, plaintiff's motion eliminating number 7. Okay. And who's taking that argument on plaintiff's side? Does that meet the needs? Is that Mr. Copperman or Mr. Kemp taking that? Plaintiff's motion eliminating numbers?
That's the motion for me to file a supplemental amendment. The motion to file the addendum.
Right, okay. But that, right, and that addendum goes to Randolph.
But it also goes to the motion to strike it.
Right, so it's tied into the motion to strike, so it's tied into 536. I'm just trying to make sure we got these taken care of for you all. AT&T's. Well, you'll tell me if there's between now and Wednesday, everyone will double check. But if you want to take those first 3 first thing in the morning, that should give ample time, doesn't it? If we start at 8:30?
Yes, Your Honor.
Yes, yes, and yes?
Yes, Your Honor.
Counsel for Trevor Herbst, is that okay with you?
Yes, Your Honor.
Which
thank
do you want first, the motion for summary judgment or the motion to strike? Which one are we doing first?
Your Honor, the motion to strike may obviate the need to do the others.
Motion to strike, then we'll do that one first. We'll do the others. Okay. I do appreciate it. Everyone have so at this juncture, I don't see that you're more than welcome to come back this afternoon. Does anyone see a need to come back this afternoon?
Not from the plaintiff's perspective, Your Honor.
Anything from Rural Water, Your Honor.
And how about Trevor Herbst?
you. No, Your Honor.
Okay, then have a great rest of your day till we see you on Wednesday, and I won't even be seeing, I think, any of you tomorrow on my rest of my matters on my calendar. Have a great one.
Thank you, Your Honor. Thank you so
As long
much.
as there's an NEA filed. Thank you. You can go off the record, and thank you so much.